All right, here we go, and want to kick off and thank Liz first off for the treats that you provided to those of us here in person. Very, very kind. And Binu, thank you so much for taking your time to talk to us today. I know this has been a bit of a hotbed of a topic about what to do and all the implications when a buyer won't close. So I'm gonna give you the floor and we'll kick it off.
Okay. And just forgive me, my voice is a little bit rough today, but I'm going to power through. So when I first got the topic for today, and I started to make my notes, that was, I think, where I started with in terms of sort of all realtors trying to protect themselves is to start with your note taking. So even before you have a situation in which you feel like a deal is going to fall apart, you should have as a standard practice making sure that you're taking accurate notes about every step, every communication that you have between your client, between the other agent, any communications that you have. So if it's emails, starting with sort of a standard practice of sort of compartmentalizing your emails by deals, using an email program or whatever to just have that set up. If there's verbal conversations that you have with the other agent or your clients, to take notes right after you have those conversations about sort of, even if you think it's an innocuous question or concern or query, to make notes about that. Sometimes people will use voice notes on their phone just to confirm what they say. And the reason why is because if you look at the case law of when deals die and they have to go to court, you'll see judges going through a very, very detailed analysis of every step and every communication that's there. And the timeline of when things happen is very, very important. And if you read some of the cases that I'll mention later, you'll see that sort of same analysis over and over. And the reason why is because when the deal doesn't close, the buyer is looking for any small defect in the vendor or the vendor's agent or the vendor's lawyer not complying with what they need to do. So you might think it's a small and innocuous detail, but having a note as to why these conversations took place is quite important. It's also important because if a deal dies and you need to be a witness eventually in an examination for discovery or in a trial, that might be a year later, that might be 2 years later, it could be quite a bit of time later. And I've been in examinations where realtors don't necessarily have perfect recall of what is happening. But if they have their notes, they can go back and basically be able to refer to them and answer some of these questions. And some of the things that come up when deals die is that the realtor is often the first person who knows that there's going to be some type of a problem. So they usually will get some indication from the other realtor for the buyer or their clients that there's some type of an issue that's come up. And that's important because of sort of a legal concept, a thought in terms of what's called anticipatory breach. So an anticipatory breach is that the buyer is indicating to the seller, typically sometimes through solicitors, sometimes through agents, that they don't intend to close the transaction. And why this is important is because if there is a true anticipatory breach, so the buyer has indicated, I'm not going to close this transaction for whatever reason, and documenting that and knowing that that has taken place can sometimes solve everything that's going to happen thereafter. So what ends up happening is the buyer says, I can't get financing. I'm communicating that to my realtor. They're going to communicate it to the other realtor because the buyer is probably trying to get out of the deal before the closing date. And what the law basically says is that if they give that indication, that even if the buyer comes back later and says, well, no, we want to close, the vendor might be able to rely on the fact that there was this anticipatory breach, and anything that happens thereafter is really back on the buyer and the buyer's responsibility. So it's important to have a sort of a clear line of communication to know when these things are happening. The second part, obviously, is that when you get that indication that there could be this anticipatory breach, the first thing that you probably want to do is talk to the vendor solicitor as well, to basically make sure that there is some documentation of that. So sometimes the vendor solicitor is going to have to write a letter that says, we've received this information, we believe there's an anticipatory breach, and then, and basically preserving the vendor's rights in those situations. So sometimes those issues that the buyer has brought up cure itself before the closing date, but sometimes they don't. And if they don't, we have to make sure that we have sort of a clear indication as to the series of events, the timeline, and whether this inquiry about whether it's going to close or not, it's a serious one or not. If it's something with respect to financing, it's probably more serious. If it's something that's a smaller issue, they're happy with certain things about the house, then it might not be to the level of an anticipatory breach, maybe just conversations about the deal not closing. So let's assume that you've taken all your notes, you have everything covered in that way, and we get to a point where we're on closing day and the deal doesn't close. So what typically happens, and maybe you all know this, is the vendor solicitor has to tender. So there's a very specific process in terms of tendering. And we hope that the solicitor knows exactly how to do that. But basically, it's showing to the other side that the vendor is ready, willing, and able to close the transaction, and that the purchaser is the one who is breaching their obligations under the agreement of purchase and sale. So let's assume that the lawyer has done everything right on the vendor side, and the deal doesn't get closed on the completion date. It sort of branches off into two possible scenarios after that. The first possible scenario is the deal could get revived. So there could be negotiations between the buyer and the vendor through their agents, maybe through the lawyers, to revive this deal. So that sometimes happens, but it's very, very important to be very clear about a couple of things when you're reviving those deals. It probably should go through the lawyers if the deal is going to be revived, and then any communications between the agents are passed on to the lawyer. The reason why is because sometimes what will end up happening is that the buyer's agent will come to the vendor's agent and say, well, we want an amendment. We want to amend the closing date. We want to amend with certain terms. And it's really, really important that the lawyer be in the loop of everything to make sure that those amendments aren't signed necessarily, unless it's been agreed upon between all the parties and their solicitors. So it's really important to basically say, okay, I can take in that information, but I'm going to pass it on to the vendor's solicitor, because they're going to have a talk with the vendor of whether should we revive the deal, should we not, what are the consequences, sort of back and forth. And if the situation is that the vendor says, okay, I don't want to revive the deal, but there's some type of understanding or agreement between the buyer and the vendor that the deal's dead and we're now going to release each other from the transaction. That sometimes happens. And the agents will use sort of the standard form release, the RIA standard form release, to either determine where the deposit's going to go and what the party's obligations are. It's important to understand that even if your client agrees, so let's say we have a situation where the vendor says, okay, I'll release the purchaser, they give me the full deposit, and everybody goes their own way. And you might look at it and you say, okay, well, that sounds good. My client is getting the full deposit, whatever it is, and everyone's going to go their same way and they're going to relist the property. However, you have to be on guard for your client, who's the vendor client, who's going to sign that release. After the fact, they might have concerns with signing that release. And you might not think that there any concern would come up. But if they're in the process after that release is signed to relist the property, and they have to cover that property's carrying costs for a considerable period of time, they might look at that amount that they received from that deposit as being too low below to compensate them for the situation that they're in. And now they're going to look at it and say, this property's been in the market for so long, I've had to sell it for considerably less. Who's responsible for it? And now they say, well, the buyer's responsible for it, but they have a release. Well, who else is going to be responsible for it? Well, people who gave me advice to sign the release. It might be a lawyer, it might be an agent. So you have to be very careful. So while it seems very straightforward to get everyone to sign a release, it's very important that, and probably should be part of the standard practice, to say, I can draft up that release, but you got to go see a lawyer first before you sign it. And that lawyer has to take some notes about the discussions between that vendor client and the lawyer about all the risks that are involved and all the risks that they're going to be assumed. It absolves you from some of that responsibility, also covers everybody in terms of responsibility, and also gives the vendor a chance to understand sort of the process of what's going to happen in the future in terms of relisting a property and sort of what are the risks that are involved. So it's important at that point to basically, a mutual release sounds good in terms of sort of dealing with that first problem, but other sort of associated problems can come up after that. So let's assume we have a situation where we don't have a mutual release. The deal doesn't close on the completion date. We have a situation where the vendor lawyer has tendered. They've done everything they can to preserve their the vendor client's rights. What do you do sort of after that? Well, it's clear that if you want to recover from the purchaser, the buyer, in terms of any of the vendor's costs or losses that they have, is you have to mitigate your damages. So it's important at that point to sort of follow once again, a standard procedure of what's going to happen at that point. So what I typically recommend clients at that point is to at least get a consultation with a litigation lawyer to have them explain what the court process would likely be. That's number one. Client needs to know what are sort of the likelihood of success in terms of bringing an action against the purchaser. The second situation is, and agents have said, like, when can I relist the property? And I think the answer to that is when you know the deal is dead and there's been communication between the realtor and the solicitor and the client, and this deal is not going to get revived and we need to relist it, is to relist that property immediately. You don't want to have a situation where a purchaser is going to say, as their defense in court, that the fact that the vendor did not relist this property immediately is a failure to mitigate their damages. What they're trying to basically say is the market conditions immediately after the breach might be different than 30 days later or 60 days later. And now purchaser is now using this as a defense and saying, I'm absolved from all responsibility now because the vendor didn't mitigate the damages. It's also important to understand, if you're relisting the property, this might be self-evident, but listing the property on MLS is very important. It's an issue that continues to come up in the case law as being a reason why the purchaser shouldn't have to mitigate or to pay damages, and there's a failure to mitigate. You need to make it available to all parties to make offers. Now, that doesn't necessarily mean that if you get an offer outside of the MLS system for some reason, that's a bad thing. But if it's lower than what the agreed upon sale price in that first deal was, then you have some issues that you have to deal with. The other issue is, what do you list the property at on the second listing? And it's pretty clear from the case law, it should be based on the original listing price. Not the agreed upon sale price necessarily, but the original listing price. The reason why is because there's case law in terms of what to do where you have a situation where there's a reduction of the price over time. So there's a case in 2019, Ontario case Freeze versus ARFA, and they ended up reducing the price from $590, which was the original listing price, and accepting an offer. They had 2 or 3 reductions and accepting an offer at $425. And because of the steps they took in terms of reducing that price, the vendor was able to sue successfully the purchaser for the difference between 590,000 and the 425. And what they did in that situation was they listed the property at the original listing price and they left it open for 30 days. Obviously, the realtor took accurate notes of all of the offers that came in. After that 30-day period, when they did not receive an acceptable offer, they reduced the price again. In this case, they reduced the price about 12%. They left it open for another 30 days. No offers. This is back in 2017, I believe. And then they reduced it another 16% after that. So the purchaser at that point is saying, okay, all I know at this point is the property sold for 425, and I was going to pay, I think it was listed for 599 originally. I think it was 590 that was the agreed upon price, and now they're saying, okay, this is an improvident sale. I shouldn't have to compensate for this. And then the vendor is saying, I got a timeline of exactly what we did in these circumstances. So now it goes in front of the judge with this evidence, and the judge says it's completely reasonable. It was left open, there were no offers, the reduction was reasonable. What the reduction would be obviously depends on the circumstances. You're probably going to have some sort of analysis as to what those, the market conditions are. But at that point, the market, I guess, based on the case, was starting to adjust itself. So the other issue that came up in that case, and comes up in cases all the time, is in terms of determining the value of the property is to get an appraisal immediately. So if you have evidence as to what the value of the property was when the deal died, it's important to get that. If you get the appraisal later on, it doesn't ruin your case, but it can be, once again, another issue that the purchaser is looking at to say, okay, we might not have an accurate view as to what the value of the property is. So it's important to get an appraisal and then follow sort of the standard 30 days and 30 days if you're going to go through the sort of the idea of price reduction. And like I said, in most of these cases, it's pretty clear that if you follow that sort of standard procedure, a judge is going to look at it and say, so this is well thought out, well reasoned as to why that happens. If it's outside of that sort of typical form, they might say, okay, well, there's some issues here as to why that's the case. They might think that the vendor was sort of trying to get a quick sale, minimize their costs, and that's to the purchaser's detriment. So we don't want to have that being an issue. And I think my sort of last point in that, and then if there's any questions I can answer that, is this idea of the first deal is dead, purchaser has breached, the vendor has relisted the property, and the purchaser makes an offer on the property. So now there's been price reductions, the original purchaser says, I'm gonna make an offer. And they sometimes will do that because there's price reductions to mitigate their own damages and try to say, okay, well, I'm putting an offer in. If you don't accept my offer, you can't sue me for it. And the case law basically is saying you don't have to accept their offer. Especially if it's an issue with financing, you don't have to, as a vendor, take the risk anymore. You don't have to go back to the original purchaser and say, okay, well, I'm going to sell it to you at a reduced price, because you could be in the same situation that you were before. And it's reasonable for the vendor to say, I'm not going to accept this offer. We went down this road before, and that's fine. But there's risks in terms of sort of how all the parties, the vendor, their realtor, the solicitor, feels about this new offer coming in. Sometimes there's this pressure that a realtor would have to say, okay, well, maybe we should just take their offer and then it'll be done. And they're putting a lot of pressure on us to accept their offer. And they're throwing things out saying, we'll sue you if you don't accept the offer, and so on and so forth. So it's really important, obviously, to get legal advice, but to understand that there is no obligation for that vendor to accept that offer from a purchaser who's breached before. Regardless of what the terms are, whatever, regardless of what the assurances are, the vendor doesn't have to. Now, if the situation is that the offer is something that the vendor wants to accept, then that agreement has to be carefully crafted to make sure that all the risks are being dealt with if there's another breach or other issues that come up, in the future. So hopefully that summarizes, I think, sort of some of the steps, some of the considerations that a vendor's agent would have. But I don't know if there's any specific questions about anything that I spoke about.
With regard to the listing price, we've just come through the market that everyone was listing low and getting, 400,000, say, more than the asking price. Then it wouldn't, but then subsequently, by the time the house was meant to close, maybe the market had changed and now that was no longer the case. Wouldn't it then be reasonable to list at the sale price instead of
I think that's why
list price?
The appraisal is important. Because if you have the appraisal, then you have sort of an accurate idea. If you're going lower than what the list price was originally and the sale price, then once again, you're gonna have to have some evidence as to why that's the case.
I'm suggesting you go higher.
Sure. So if you go higher, then you also have to have some evidence of that as well.
Yeah.
Because the question obviously is that you're trying to recreate the market conditions that you had previously. So if you go higher and you have an appraisal that says this is what the value of the property was, and your notes say, my original thought process that I provided to the vendor was, let's list low, we'll get multiple offers, then that's the methodology, and then it worked. Then you have a situation where you say, okay, here's my methodology, here's what the appraisal says, okay, I can justify listing at a more accurate figure to what the market indicates. Because either of those changes are probably reasons why the purchaser is going to say, well, it's not the same conditions. But if you have the justification for it, then you can say, okay, well, what we wanted to do was list higher. It's in accordance with what the appraisal says. Because if you list higher and then you have a situation where you don't get any offers, the purchaser might say, as their defense, well, you listed higher, you didn't get any offers, and now you're reducing the price every 30 days, let's say. And now it's getting lower than what the agreed upon sale price is. And that is something that I'm not going to be responsible for because it wasn't sort of following that standard practice. But if you have evidence that shows, okay, we got an appraisal, we wanted to list it what the market condition was, that was what the sort of the thought process was. Judge is going to look at it and say, okay, that was probably reasonable in the circumstances. But we're taking a snapshot of something now and then explaining it to a judge 2 or 3 years down the road, and who's not an expert in these things, trying to make sense of everything, and they really are looking at, I don't understand maybe real estate, maybe I used to be a family lawyer or whatever, but I need to know that this was well thought out.
Mm-hmm.
And if it was well thought out in terms of what that strategy was, whatever the litigation strategy or otherwise, then they're more likely to go, okay, wasn't haphazard, there was some thought behind this. Okay, this is why, I think that the vendor is going to be, will receive the damages that they're seeking.
Okay, thanks.
What if it goes to court 2 years down the road, and so 3 months out from the deal collapsing, you are listing it at $400,000 over the price, and you go into court and try and say, well, this is what it should have been, or you're based on historical data that wasn't present at the time that the whole thing collapsed. So, because you're basing it on data that happened in that 3 or 4 months after. So you can't say that, well, this is what it should have been, because you don't have any information at that time it collapsed that that's what it was.
So are you saying a situation where you don't have, like you release the property and you don't have any information from that time period?
You release it, which you can get historically, you get an appraisal done, but if 3 months down the road it's relisted, and hey, it's gone up $400,000, so we're listing it at $400,000 more, but that data wasn't available at the time when the whole thing collapsed. So how can the courts say that they're going to use that data, the appraisal at that time?
Yeah, I think the question obviously is that even if it wasn't available for the original purchaser at that time, they're just the court's trying to look at what were the conditions that you can sort of prove. So even if it's a situation where there's these wild fluctuations in the market, they're not going to judge what the original deal was, what that original
I was
price
thinking
was.
subsequent listing, but
Yeah, so they're just gonna look at the subsequent listing. So if you have some indication as to why you decided to list for higher or get higher, then that's fine. Now, the situation is if you listed for higher and you got higher than the agreed upon sale price from the original deal, then your client's fine. At that point, they're fine. They've received more. Depending on how much more and the quantification of what their damages are, depends. So for example, if they sold for, the original deal was $750, they sold for $800, that may be enough to compensate them if we take the deposit that was forfeited and the increase in the price. But in unique situations, it could be not enough compensation for them. So, they might have huge carrying costs on the property and it's not enough. But if it's more, then it's once again, it's a situation of just looking at, is the compensation, fair and reasonable in those circumstances.
Question that comes up all the time when you're going through and explaining in order to get a large deposit and all of that to your clients is what typically does it cost for them to sue if there was a breach of contract? So, if we're looking at getting $60,000 deposit on the property and that gets held up in court, will that really cover everything and the seller's expenses if that's what the court rules?
Indeterminate. It really depends on the circumstances. You might have a situation where things are resolved early on. Litigation lawyer sends letters to the other party's lawyer. There's negotiation that goes on. Maybe they go to mediation, they solve the problem, they reduce their costs, that's fine. But most of these cases that go to a final determination by a judge, you're talking, like I said, it's 3 years. It's almost the sort of standard in that case. And 3 years of litigation is not necessarily $60,000. So, because even if it's a situation where you get to sort of an examination for discovery stage, we're somewhere in the middle of the litigation process. It's a lot of legwork that the lawyers are doing, a lot of costs that they're incurring. So it's a situation where I don't know as a realtor that you should be necessarily, I don't know if the word is concerned, but you can't control that variable. You try as best you can to get a deposit that's going to cover those costs, but it's also a situation where that it's sitting there in the brokerage's account. The client is not accessing that money. They're still paying that litigation lawyer up front. They're probably not going to work on a contingency, so they're not going to want retainers on a regular basis, and maybe they'll get recovery at the end of the day. But it's not going to be upfront. They're probably funding that litigation directly from their own pocket. And this is also a factor in terms of vendors looking at it and saying, well, is it something that I want to sue for at all? And the balancing of that, and talking to their lawyer about sort of the pros and cons of doing that. Everybody wants to sue originally, but when they get the estimated invoice as to what it's going to cost, then they might alter their strategy and say, okay, maybe a mutual release is something that is willing to negotiate.
So in general, the larger the deposit usually will help mitigate the damages at an earlier stage.
Yeah.
As opposed to something smaller, because
Of course.
ahead says the buyer.
Yeah, and you could also have situations where the deposit, and it's rare, but it could have situations where the deposit is disproportionate to the loss of the vendor side.
Right.
So sometimes you have purchasers coming back and saying, it's $60,000, but we resolved this very quickly.
Yeah.
And maybe you shouldn't get all of that deposit.
Right.
Now, typically in most cases, there is a forfeiture of the deposit if it's proven that the purchaser is in breach. But if it's disproportionate, you see some cases where they say, okay, this is an exception to the rule, it's disproportionate, maybe some of that money should go back to the purchaser, but it's the onus is on the purchaser to prove that it's disproportionate in the circumstances.
Good.
Anybody who's joining us via Zoom, I just don't want to miss out on anybody there. Did anybody who's joining us there have any questions for Binu? Feel left out?
Tina had a question.
All right, sorry, Tina.
No problem. So in real time, so say a deal doesn't close on Friday, and the following week goes by, usually you're trying to get an extension or try and figure out what's going on, but you do want to mitigate that loss, especially in a market where month over month you're seeing a decline, but the buyer won't sign the mutual release.
Mhm.
So
You don't need a mutual release to release
to
the property.
accept another agreement of purchase and sale, doesn't need to be
So
conditional upon the release of a previous agreement?
All you're concerned about is that the vendor solicitor has tendered, clearly indicated there's a repudiation of the contract, and has given instructions that say to the vendor or to the realtor, you can relist this property.
Okay, so I've had it in a busy market before where, you know, maybe there was other buyers, like you could pull out, you know, maybe there's another agent that said, hey, let me know if anything's going south, we'll jump in. So maybe like even that weekend, you could get another agreement. Would you suggest making the acceptance of that offer conditional upon lawyer review?
Yeah, absolutely,
Okay.
100%. Because we don't know sort of what's going on necessarily in the background. Sometimes what'll end up happening is the deal doesn't close on Friday, the weekend's coming, the vendor is frazzled, and they're saying, Tina, please get that other offer that was on the table before, bring them back, let's, accept their offer. But you don't know if the purchaser's lawyer has sent a letter saying these are issues that have come up. Maybe it's an improper tender, maybe it's all of these other circumstances that come up. So if you're gonna accept an offer on a Sunday night, and then on Monday morning you have a situation where the purchaser is saying, no, you can't. Yeah, we're closing, you can't get out of this deal because you did something wrong. Then you're in a situation where you have to make sure that you're not getting your vendor in a situation where they have two simultaneous deals. For a variety of different reasons that could be a concern. But yeah, you want to make sure that there's that communication. I know the client's going to be frazzled. I know the client's going to be in a rush, but you have to tell them, okay, we can deal with these issues, but we have to make sure that everybody's on the same page. Your team has to know every step of the way, because we have situations that happen here in our office where that's exactly what happens. The deal goes south, we tender, we tell the other side there's been a repudiation of the deal, and you don't hear anything from the purchaser's lawyer. They just completely ignore our correspondence. And then all of a sudden, they wake up on Monday morning contacting us saying, we're ready. Everything's great. What do you mean? What do you mean the deal's gone south?
Yeah.
Or you get a letter from a litigation lawyer, on the Monday morning, and where the purchaser has run out and said, okay, I got a litigation lawyer and I want to revive this deal that way. Because sometimes it's an issue where the purchaser and their own solicitor or realtor have issues, and the deal hasn't closed because somebody on their team hasn't done what they wanted to do. So the purchaser client's going, well, no, we can't close. My lawyer didn't do what they're supposed to do, and we want to revive this deal. And now it's infighting on that side. So you want to make sure that the vendor, it's very clear, okay, if that comes up later on that Monday morning, it's been dealt with before we accept a new deal. So then the vendor solicitor could say, no, thank you for your letter. The deal's done. We did everything properly. Clients relisting the property, and away they go.
Yeah, because I seem to remember there were times when property would sell lower than what they could get at closing. And so the seller's like hoping it doesn't close, because Monday they might get another $100,000 more. But if it's not the fault of the buyer, but they still didn't close on closing day, that seller's gonna want to take the higher offer.
I mean, of course, yeah.
So if it's not the fault of the buyer, like say there's solicitor dropped the ball, or there was one time where one of the banks had a problem and they couldn't close deals on a certain day, what would happen then?
Well, you got to make sure that first deal is dead and really dead, because this sometimes does happen.
Yeah.
You have a purchaser who's ready to close, but their solicitor is so negligent in what they're doing that they haven't even picked up the file until the last possible minute. And the solicitor, we've had these situations, is not understanding that a completion date is an actual completion date. And we have to get this actually done on this date.
Yeah.
And they're like, I'm on vacation, I have this, I have all kinds of issues that are going on. And the clients are, or the purchaser and the seller are basically communicating, saying, no, we want this to go through. I just hired the wrong person to be able to get this done. It's not their fault. So you might end up in a situation where the purchaser's coming to that closing day and going, nobody's contacted me to sign my documents, to do anything. I'm ready, but somebody has dropped the ball. And then if you accept a new offer just on this situation where you haven't assessed all of those issues on the purchaser's side and given them the opportunity to cure them, then you have a situation where the vendor might be at fault at that point. You have to be sort of very cautious. You're not waiting a long time to relist the property, but you're also saying, okay, I still have these issues that we have to deal with on this side of things. And we want to be very certain that when we communicate to the other side that we're not getting anything back that gives us any indication that there is some type of a concern that the purchaser is actually ready to close the transaction. Oh, sorry.
What if you relist the property and the incompetent agent that messed up the deal in the first place brings you another offer with a different buyer? Happened.
I think the situation is you can't discount that offer because there's a new client.
Isn't it a conflict of interest though?
No.
He's already involved in one offer that's falling apart, and all of a sudden you're the same agent is submitting another offer?
Well, the question is, that's not for anyone to deal with. That's for them to deal with on their side. Yeah, you don't have to worry about the conflict necessarily. So it's not your job to evaluate whether you should be presenting an offer to me or not.
Alright.
You should basically say, I'm assuming at this point you've dealt with that issue, and maybe it's a situation where the agent and the client maybe have falling out or whatever. They're dealing with it with their lawyer, and the agent now says, okay, well, I do have another offer. It's not necessarily the realtor's fault. Should they be involved? Probably not. But if it comes in, you have to present it to your client. And there's just no other way to get around it. It's part of that whole idea of mitigation. If you say, well, I'm not going to present it because person X is presenting this offer to me, I'm not even going to bother giving it to the vendor, it could be a concern. Because then we have a situation where it could be, once again, strategy at this point, where now that first purchaser is going to say, well, offers weren't presented properly. And the vendor didn't even have a chance to consider it. And that's an issue. And it sometimes happens in situations where it's a family member. You see that situation happen, where all of a sudden a family member is coming out of nowhere and saying, well, I'll submit an offer because they've contacted me and said, the deal went sour, I'm gonna get sued. And then they say, okay, you know what, their uncle or whoever saying, okay, well, I'll buy the property for you.
I have a feeling that's what went on. Fortunately, we did get another offer.
Yeah.
But would that not contradict our MLS rules? Like our MLS rules are like the part where the agent comes with a different client. We are not allowed to refuse someone because the MLS rules dictate that.
We're not.
The other thing about it is, as Tina said, the one part, getting a mutual release, accept the offer conditional upon receiving a full mutual release from the first party. It simplifies everything, doesn't it?
Well, they won't sign
No.
even on Tuesday. I've had it where the buyer is just not going to sign the mutual release because they want their deposit back. Because usually the mutual release is contingent on a deposit being forfeited, right?
That's one of the reasons I usually get, when we remove the conditions, this offer is firmly binding and the deposit is now non-refundable.
Yeah, I mean, I'll be honest with you, that terminology doesn't really mean anything. No, because you can't contract a situation in which you don't know the circumstances. Because even if you say it's non-refundable, what is the actual facts of the breach?
I've been in a 4-year legal battle over that non-refundable deposit.
Yeah.
In the 80s, it was 75 grand, which was a king's ransom. I know where you're coming from that end, but as far as the secondary offer coming in, I just thought the simplicity of receiving a mutual, and like you said, it doesn't sign it, you're moved in. Sorry.
Yeah, it's just, we have, when we have extensions of deals, we often have clients saying, or using, like, we wanted to make sure it's a non-refundable. It's really, really important to understand or to explain to a client, maybe it's the lawyer's responsibility more than the agent's, of understanding that word non-refundable. Yes, it's preserving your rights, that you're making it clear that it's non-refundable. The client has to understand that it really is dependent on the circumstances of the transaction. And sometimes it is, sometimes it's not. They also have to understand the difference between non-refundable and the money is going to be directed towards immediately to you. Non-refundable means you're not going to get the money back, purchaser. Vendor clients sometimes think a check is going to be written to me, and that's not necessarily the case. You're going to have a release or a court order to get access to those funds. So it's really important to sort of differentiate some of those circumstances. It's case by case.
I have something, just to bring up that a few clients in the past, when the market was high and purchasers weren't able to close, we'd get phone calls where the vendor says, well, that's okay. The money that's in the trust account of the brokerage, I'm gonna get that. And they'll tell me that their agent said that deposit, if the purchase doesn't close, is mine. And it's not there. And I just wanted you to maybe stress that. It's not automatically theirs if the purchase doesn't close.
Yeah, it's something to be very clear to the client. Access to that money depends on a third party. The brokerage has the funds. The brokerage has to follow their own rules to release those funds. They need to have proper legal direction to release them. And clients don't understand that. They think that this is sort of a freewheeling situation where money is being passed back and forth between parties and the deal died, I get that money. No, it's very important to say the brokerage is holding it. There's only really two ways to get that money. A mutual release directing the money, or a court order. And be prepared for the fact that that money is going to be there for a significant period of time. If you get it earlier, great, because you've dealt with it and the parties have resolved it, but otherwise, no. And sometimes they're counting on that money for some reason being released to them as soon as the deal goes.
Well, maybe to cover their expenses because they've already moved and now they're stuck paying 2 mortgages. So they need that money, but they're not gonna get it.
No, and sometimes it's even a situation where it's almost it's a punitive situation for them, where they want to punish the purchaser and just get this money right away and say, purchaser get lost. Well, hold on a second. Make sure if you're going to tell them to get lost that you understand sort of what your obligations are. You want to take the emotions out of it at that point.
I think it's important for our agents to read that clause to your client. Just don't say this is the deposit. Because in the clause, it says that deposit is being held in trust to the completion of this transaction. And at that point in time, it's going to be credited to, it doesn't say this is the seller's money that the brokerage is holding. And I think it's really important that that does get expressed so that they understand what that money actually is. It's not their money. It's the buyer's money being held in trust till completion. And, take that 2 seconds just to explain it, because a lot of sellers do have that, that's my money, it's my money, it's not.
Almost all of them have that.
Yeah, it's not your money. It's nobody's money, really, it's in trust for completion.
That could sit there forever.
They can.
So, in the event I had a deal where there was an incompetent lawyer, realtor, and mortgage broker, and it resulted in multiple delays to the closing. It did eventually close, but each time we ran into a delay before we'd agreed to it, because the lawyer just said, well, we'll just close another day, and I'm like, no big deal. Yeah. So we said, okay, we'll agree to it, extending the closing a week, whatever, for a further non-refundable deposit of $5,000, whatever it was, right? And did that a couple of times. You're saying that still, because it's a deposit, it remains in the broker's hands, and
It's our lawyers. That non-refundable deposit's in the lawyer's trust.
Not necessarily, not necessarily.
Yeah.
In most cases, it'll stay with the brokerage, but it depends on the terms of the extension. But either way, if it's in my trust account or Sutton's trust account, it's in trust, I can't touch it. And so it's one of those situations where I don't want it in my trust account because it's not my funds and it's gonna be something that's open and disputed. It's probably better in Sutton's trust account or the broker's trust account. But yeah, it's a situation where if they say non-refundable, it really depends on the circumstances. So for example, purchasers are going to try to minimize those additional deposits, and sellers are going to say, you got to show me that you're serious about this. So you might have a situation where they're asking for, each time $20,000 or whatever, and maybe that purchaser says, fine, and then you end up with a situation where that deposit is $100,000, and then the deal doesn't close. Once again, it's depending on the circumstances. So now it's up for the vendor to say, these are the circumstances of the breach. We gave them extensions, they provided the deposits, I'm entitled to that. Forfeiture is probably likely, so the court will probably say the deposit's forfeited, but there's always exceptions to the rules. So, that's just the way that the court system is. There's a rule, and then there's every other exception, and you just have to be so wary about that, and the client has to be aware of that. Hard and fast rules always have an exception. Are there any other questions?
I had one quick. The amount of the deposit, is it a consideration when factoring in compensation or loss on the part of the seller? So I guess what I'm trying to say is, does it count towards sort of the, okay, I've got my costs of my carrying costs for my mortgage and my legal fees and my X and my Y. Does the deposit amount affect what you can claim on there, or is it a separate, completely separate entity?
Separate. Yeah, it's completely separate. So what the vendor is going to do is they're going to quantify their carrying costs and the losses that they have. Typically, a judge, if they've done everything that they're supposed to do, is going to say, okay, you're going to get recovery for those costs. And on top of that, the deposit is forfeited.
Okay.
Unless, like I said, it's a situation where those costs plus the deposit are disproportionate to the actual circumstance. And you see it sometimes in commercial transactions where you have huge deposits, millions of dollars in deposits, but the losses don't sort of compensate that. So we quantify the carrying costs, and then they say, okay, hold on, you're going to get your carrying costs, you're not going to get all of the deposit back. Or credited to you. Some of it will go to the purchaser. It depends on the circumstances, but they're separate. So for example, in the situation where you say, okay, I've quantified my cost at $10,000, but I have a $20,000 deposit. Do I just get the 20? No, probably gonna get the 10 and the 20. And pre-judgment interest and post-judgment interest and costs,
Right.
Legal costs and everything like that. And legal costs, just so people are aware, it's never full recovery. Whatever you're paying to that lawyer, you're not getting all of it back. It's most likely that courts these days are saying it's about 50%. And even then, if you get in front of a judge that doesn't know, exactly what they're doing, people are getting less recovery. And they're being so sympathetic to other parties, they say, okay, we're gonna fix costs at a much lower amount. So going to court is a huge risk in terms of the costs that you're going to incur and maybe not get full recovery.
One last question, if I may. A firm sale, regardless of whether it's 2 days after it's firm or it's 2 days before closing date, so firm and conditional, does the all of a sudden mysterious presence of a mutual release in your inbox from the buy side qualify as anticipatory breach?
I think the question of just a mutual release on its own isn't. But then you want to find out the circumstances behind that. So I think the vendor solicitor at that point would say, my client's been presented with this mutual release, what are the circumstances? A good purchaser's lawyer isn't going to answer that. They're just not going to answer that inquiry. Because they don't want us to put anything in correspondence that says that my client's probably going to breach this deal. And they're going to want it to be sort of under the surface of things. So they're just going to ignore it until the closing date and deal with it at that point. And they're trying to get sort of the parties and the realtors to, negotiate sort of through the side door on whether this mutual release is a possibility or not. Because this happens, the parties don't agree on the mutual release, and then it closes anyway. You know? Then it closes, it's fine, everybody's happy, but then there's just that few days of like, oh, that's a possibility. It probably has to be pretty overt in terms of we're not closing. We're letting you know this is the reason why, not just we're throwing out the idea that we might not close. Because it happens. It happens. People get cold feet. They get into a situation where they get into searching through their financing options and then they realize I can't afford this. Or if I can afford it, it's not at the terms that I want to pay. So can I float this idea out there through my realtor? It happens, but it's not for a level of.
So even a buyer signed mutual release that arrives is not in and of itself. So I guess the key takeaway for me anyway is regardless of what the communication is, that needs to flow to the seller's lawyer for written direction back to the realtor on how to proceed. Whether it's relist the property, whether it's pass along that information. Okay, thank you for that.
Sorry, just something I thought of one time, and this is probably not legal, but I'm curious to take your take on it, is, so I had one where they were bailing on financing, like it was supposed to close, and they said, no, financing's an issue, whatever. And I gave them an extension based on, and I can't remember if we did it verbally or in writing, that they had to talk to our mortgage broker here so that we could see if we could do the deal.
Okay.
And we did.
Yeah.
But I don't know, I can't remember how I did it, I doubt I put it in writing, because I usually put things I don't think are too copacetic. but I remember giving that stern option, like where it really wasn't an option.
Yeah, it probably wouldn't be something that we put in writing.
I don't think I did, if I remember correctly. I think I was yelling, actually. I don't remember everything I said, but the purchaser had to go to, it was Rob at the time, and have him run through the deal. And we did get financing for them and make it go together.
Yeah, it's not that often that it happens. I think maybe once or twice we've had situations where, purchaser's lawyer has said to us their client's having trouble getting financing, and we just, out of the goodness of our heart, say, here's some options of people who might be able to help you.
Right.
And, if they take it, they take it. If they don't, they don't. But I don't know if we can insist on them, using somebody that we know, but we kind of just throw it out there. Sometimes they don't, sometimes they do.
Yeah.
Solutions are.
In this case, the buyer actually didn't want to close. They didn't want to purchase.
Yeah.
But they couldn't they had just gone to their bank and didn't.
Yeah, and if they wait till the last possible minute and they get an answer they don't like,
Exactly.
they may not know.
They didn't do their proper process where they put things in place sooner, so they ran out of time, and by the time they got to there, it was done. So we just extended it.
I mean, it's not really on this topic, but I think it's a situation where, for most, if you're on the buyer side of things, most clients think things happen by like this, just like this. I'm gonna open up my phone, I'm gonna click an app, and I'm gonna get financing. And they don't understand at all what the process is. Yeah. And just this sort of immediate, world that we live in, they just don't know the steps. And so to anticipate that and let them know ahead of time, this is serious, you gotta get your stuff together, there's a lot of paperwork you have to get, to sort of save that at the end of the day is probably a good idea, because they need to be reminded 4 or 5 times. If you send them an email with 4 things in a list, they've read one of them, and they've ignored all the other 3 things. It's too much information for people to absorb one time, and you need to sort of continually, gently nudge them towards the eventual goal. Otherwise,
Number 1, now how about number 2, 3, 4?
Exactly. Oh, thanks for getting number 1 done. We got to remember to do this. Yeah, and they need, hand-holding. They're not very good at direct conversations about things. They just need sort of gentle nudges to where they need to go. It's like a toddler. They need to have their hand held, taken to where they are. Okay, you do your thing, and then take them to the next station, and the next station, and the next station. So we need a lot more help these days.
Yeah, and the expectation is to have that assistance. And if you've got an agent that's kind of like, I just do the paperwork and that's it, then you've got usually last minute calls, because the buyer doesn't know what the heck they're doing.
The only buyer I ever had that didn't close was my son. He didn't listen to me, as he said, oh no, my friend is gonna do the mortgage instead of who I recommended, and I recommended a lawyer, and he goes, no, I'm gonna use this lawyer because he'll come to me. And so it's all good, and come for closing day, no, it actually wasn't. His friend hadn't even started working on the deal, and the lawyer, the buyer, the seller's lawyer, said, okay, well, we'll give you a 2-week extension, and you do not use that mortgage broker. We're not interested in, like, we won't give you the extension if you use that mortgage broker. You have to use a different mortgage broker. Use the one your mother told you to use.
Who knows best?
And the lawyer that he chose had something that he wasn't allowed to register properties. I mean, it was just ridiculous. It was my son, it was so embarrassing. But anyway, he paid his extra $15,000 non-refundable deposit, and he got his 2 weeks, and boy did he hop to in those 2 weeks. He got everything done, and it closed, and he still lives in that lovely home.
So in that scenario, he paid an additional 15,000, like it didn't
Deposit.
ultimately come out of the, like he.
It's like
in
an
the
additional
end-
deposit.
So it came off the purchase price.
Yes.
So he wasn't out 15, it didn't really cost him anything.
No, but it was, if he hadn't have gotten his
Mommy's
act
story.
together within 2 weeks, then he would have presumably lost that $15,000. Yes, he probably.
And there might have been some other small terms or whatever to cover those 2 weeks
Yeah.
in terms of the vendor's.
And I had
costs.
to write the check, I wrote the check for the $15,000, and I wrote it to the lawyer. He wanted it in his trust fund, he didn't want it in mine, because I guess he knew I was his mother, he didn't want it in my broker's trust account.
Sure.
I mean, how embarrassing is that?
Oh,
It happens,
embarrassing.
it
I
was
wouldn't
great.
want to be your son when you got pissed at him.
Well, we have taken a tremendous amount of our 30 minutes to thrive. It's been an hour and thriving. We really appreciate. Was there any final questions? I want to make sure I don't cut anybody off. Anybody? Is there a chat there on Zoom?
That was just, I think it was just Kelly saying goodbye.
Somebody say bye-bye?
Yeah.
Yes,
Oh,
thank you.
and thank you.
There you go. Okay. All right, well, again, thank you very much, Binu. We really appreciate the advice and guidance. And as you know, Binu is here in-house. So if you have clients that need assistance, please keep them in mind. They're always very, very good about answering our questions on a daily basis. We appreciate that very, very much. Thank you again. Thanks, you guys, for joining us on Zoom. I hope you have a great rest of your day. Thanks, everybody.
Here's-